My name is Pete Wright, and today I'm going to talk about a case that was issued by the United States Court of Appeals for the Sixth Circuit. That case is up on our website. I'm going to scroll down our website to case law on the left-hand side. Click on that link and scroll a little further down, and you'll see the AC versus Shelby County case, decision issued on April 1. At the end of my discussion about the case, I have another link to the decision. I took the decision and reformatted it in Word. At the same time, the decision issued by the Court of Appeals is located here. In just a moment, we will look at the decision. The essence of it is that it's a pro-child 504 retaliation ruling in which a building principal filed allegedly false child abuse allegations against the parents with the Tennessee Department of Children's Services. The building principal told Protective Services that the parents are just looking for a lawsuit, did not care if the child could die at school, and yet later in deposition she admitted that her statement that she could document the alleged lack of monitoring was untrue, and Protective Services closed the case, finding the allegations were unfounded, and then the parents sued Shelby County in retaliation for parents seeking disability accommodations, and the case was dismissed initially by the U.S. District Court. The Sixth Circuit on appeal said that the District Court was wrong in its dismissal. The decision itself is very, very well written, really tells a nice chronological story as to how the case unfolded, and will help parents understand what is needed in terms of the elements of a Section 504 case in order to proceed against a school district. At the same time, hopefully it will caution school personnel from filing complaints with social services when there's something else going on and the complaint could be viewed as retaliation for something else. So let's look at the actual decisions. This is the decision as issued by the Court of Appeals. I will zoom in a little bit so you can see the actual text of the ruling. But what I'm going to also show you now, because this is a lengthy decision, I'm going to show you the reformatting that I did of it. I reformatted this, copied it in Word to make some critical parts of it easier to read. Basically, child has type 1 diabetes, which is quite different from type 2. And we scroll down to some of the parts. The parents obtained state-of-the-art monitoring equipment that took automatic readings. Since the child had type 1 diabetes and not type 2, the precise amount of carbohydrates was critical, but not whether they came from candy or vegetables. And back in August 2007, before a meeting with school officials, the principal expressed her frustration in a voicemail she left for I believe it was a school, the head nurse, about the parents, and she talked about the parents and that the mother or the woman is out to lunch and goes on and on and on. I don't know what to do with this lady anymore. She doesn't have any reason or common sense, and so on. But the problem is she didn't leave that voicemail on the nurse's voicemail, but instead it was left on the parents' answer machine. So the court talks about the nature of monitoring diabetes, and that the parents were very involved in even coming to the school, training the staff at the school how to use the pump. And then the relationship went downhill, and the parents wanted testing of the child's blood in the classroom. School refused to do that. So here's more of the history. And then There were renewed requests, and the teacher supposedly hyperventilated, but she denied that initially on on discovery depositions, but then later filed a correction to that, so that became an issue in the case. But here's the critical parts. The building principal called Department of Children's Services, identified the parents as abusers. The child was being sent to the school with cookies, Kool-Aid, and candy, which makes her sugar shoot up to a very high level, and that diabetes is not being monitored at home, and that she had documentation on this neglect by the parents, and the abuse could be fatal, and 2 of the nurses left in fear that the child would die, and the 3rd was thinking about leaving. And then the principal escalated her allegations considerably, and when the investigator was talked with the principal said that the family wants something horrible to happen to the child at school, and she explained that the child could die at school and the parents are just looking for a lawsuit. So after the case was dismissed as unfounded, the parents filed their lawsuit against the school district. And jumping further down, the Court of Appeals explained, in reviewing this case, we must view the facts and all reasonable factual inferences in the plaintiff's favor. Both ADA and 504 prohibit retaliation against any individuals who is seeking to enforce their rights under the law. Requests for accommodations are protected acts, and the Court of Appeals explained that the district court misunderstood the law, and then was there a causal connection between the plaintiff's protected activities and the retaliation, and the court explains why there could be a causal connection. And it was clear to the court that type 1 diabetes is quite different from other types of diabetes. The building principal said that the parents wanted something horrible to happen to their child, including death, so they could sue. And in the in the history of the case, the school district did not try to defend the principal's allegation that the parents wanted the child to die. And so the court explains that these are issues that must be resolved by a jury. In other words, this case should go to a jury trial. And it continues on in going into whether or not there was a pretext by the school district with some of these allegations. So we conclude that a reasonable jury could find by a preponderance of all this evidence that the Shelby County's concerns about the health were pretext, and the reports were motivated by the school's displeasure with the parents and their accommodation requests. So we conclude that a jury could make this finding. So that's the end of my discussion about this recent case. If you would like to be alerted to future YouTube videos posted by Wrightslaw, please subscribe to the Wrightslaw channel. Thank you.